Once more, thank you very much. On to panel 4. So, after talking about causation and attribution, we now talk about mitigation and adaptation in concrete remedies. To chair this panel is Attorney Franco Luis G. Lopez. So, Kokoy, as we fondly call him, he's an associate of Sisip Salazar, Hernandez, and Gatmaitan, and he is currently rotating among the firm's various practice groups. He's a faculty research assistant of Professor Mike T. Chu Jr. in the UP College of Law. He was involved in researching and reporting on various policy areas, including the Philippine National Report on Global Perspectives on Corporate Climate Legal Tactics. Kokoy has a JD from the University of the Philippines, where he graduated cum laude. Our next panelist is Professor Richard N. Muallil. He is Vice Chancellor for Research and Extension at the Mindanao State University, Tawi-Tawi College of Technology and Oceanography. He has an MS in Biology from the University of the Philippines, and he also has a PhD, Marine Science, major in Marine Biology, also from the University of the Philippines. His research interests include small-scale fisheries, coral reef ecology, coastal resources management, climate change vulnerability, local ecological knowledge. The next panelist is the sole representative from the corporations, from the respondents, Ms. Agnes G. De Jesus. She had been Vice President and Chief Sustainability Officer of First Philippine Holdings Corporation since February 2014. Before joining the First Philippine Holdings Corporation, she was Senior Vice President for Environment and External Relations and Compliance Officer of the Energy Development Corporation. Because of her expertise, she was selected by an international panel as part of Asia's top sustainability superwomen honor list in 2018. Added to her corporate function, she also contributes to the field of sustainability through other responsibilities. She is a trainer of the Environmental and Social Sustainability Center of UP. She's also a member of the Advisory Council of the Business for Sustainable Development Philippines since 2014, and she's the head of the Business Task Force of the Climate Movement, Ako Ang Bukas. She was speaker and lecturer in 22 foreign and 87 local conferences and co-author of 27 environmental and social articles and books. Our next panelist is also doing double duty, Attorney Grip. He is an environmental, climate, and sustainability lawyer who has worked with governments, private sector, and various international organizations on leading law, environment, and climate issues. He's a faculty member of the Ateneo de Manila School of Law, and he is also of counsel of Magtibay Law. Now, joining us online is Attorney Niner Guiao. Attorney Niner specializes in climate change and environmental law and policy. It has been working in the sector since 2 decades ago. She currently serves as a senior legal associate at the ILS in the UP Law Center, and she heads the International Environmental Law Research Program. She's the operations director of Parabukas, and she also serves as a consultant to the UN Framework Convention on Climate Change. Another participant, another panelist online is Shibani Ghosh. He's a fellow on the Initiative on Climate, Energy, and Environment at the Center for Policy Research and an advocate on record of the Supreme Court of India. She has been a Sustainability Science Fellow at the Harvard Kennedy School and a visiting faculty at the Terry University and the Rick School of Built Environment, where she taught environmental law. Another panelist joining us online is Kanchi Kohli. He's a researcher, educator, and communicator of environmental law and policy. Her work areas cover the fields of environment, forest, and biodiversity regulation and governance in India. Uh, Kanchi has authored several reports, research papers, and popular articles as part of her work. She co-authored the course book, Development of Environmental Laws in India, published by Cambridge University Press in 2021. She teaches environmental law and development courses at government training institutes and universities. Another online panelist is Ahsan Qazi, an international law and policy consultant currently working with the chairperson of the Senate Standing Committee on Climate Change, addressing a range of climate action and policy issues in Pakistan. He's a distinguished research fellow at the Center for Environment Law, Macquarie University in Sydney. And we have a representative from the Department of Environment and Natural Resources, Attorney Rosette Ferrer. She earned her degree in AB Economics honors program from the Ateneo de Manila University before finishing her JD at the UP College of Law. She started her career at an international environmental NGO focusing on agricultural biodiversity. She joined the DNR in 2016 and currently serves as the chief of the Legal Research and Opinion Division, which is responsible for reviewing agreements and legislative bills, among others. Welcome, Attorney Ferrer. Yes, and another panelist joining online is Professor Eri Osaka. He has Master of Laws from Waseda University and another Master of Laws from the University of Pennsylvania Law School in the United States of America. He has numerous published works, including papers related to the Fukushima nuclear disaster. Professor Eri Osaka is a professor at the Faculty of Law in Toyo University, Japan. So it's all yours, Attorney Kokoy.
Thank you, Prof. Roy. A pleasant, albeit gloomy morning to everyone. I'm honored, humbled even to chair this panel. Actually, jokingly, I thought to myself, just last year, when I was beginning to assist Professor Mike in preparing the national report, I was then just a law student who had no idea what he was about to write. Now, fast forward, chairing this panel, I am now a first-year lawyer who has little to no idea about what he has to hear and say. Kidding aside, I think this underscores the importance of these sessions. As law students, just like I was in the not-so-distant past, the general presentation of the legal framework to us emphasizes two aspects, namely, first, causes of action, what our rights are under law and contract, how these are breached, and the varying causal connections, as has been discussed earlier. And two, courses of action, or the vehicles through which we rectify these breaches in a manner technically and substantively compliant with laws and procedural rules. But as a young lawyer, I've come to quickly realize the importance of remedies in the overall legal framework. Now, as advocates for our clients, the work doesn't stop in crafting the right arguments, citing the appropriate legal bases, and presenting these in a concise, coherent manner. If we're not asking, or to borrow legal parlance, praying for the right remedies from the courts and relevant administrative tribunals, then the wrong we are aiming to rectify may ultimately go uncorrected. And sometimes, given the novelty and growing complexities of corporate acts and transactions, coupled with the advent of technology, as we all know, the question also arises whether the remedies we seek can be found exclusively, if at all, through traditional judicial and administrative processes. So in this fourth panel session of mitigation and adaptation in concrete remedies, we hope to discover what remedies to seek, whether monetary or non-monetary, and whether and where to seek them out. So without further ado, I cede the floor to the members of the esteemed panel to give their introductory remarks. And may we hear first from Dr. Richard Muallil.
Hello. Thank you very much, sir, attorney, and good morning, everyone. I believe I have a presentation. Okay, sige. Well, anyway, first of all, thanks, Attorney Chuno, for the invitation. So actually, at first time, I was very hesitant because this is like totally new to me. No? The audience is very, very new to me. lawyers, no? Because you know, pagdating sa law, and I don't see, by the way, I don't see much foreigners, so let me discuss in Taglish, no? Because you know the Philippines is always like a model, no, in terms of laws, in terms of policies, when it comes to environmental protection, particularly marine conservation. But somehow we always like we are always behind, no, in terms of nakita nating output, in terms of implementation of the laws. So in fact, we mentor our colleagues from different from neighboring countries like Malaysia, Indonesia, and other countries in the Coral Triangle region. So, but then I accepted this because I think this is a good opportunity for us, for me, to bridge, no, to connect to the lawyers and see maybe how can we improve, no, our policies, our initiatives moving forward. Because honestly, I do not know much environmental lawyers. Siguro mga one, isa lang, and I don't see them much in conferences. Well, anyway, as introduced, I'm a marine scientist, so I will talk more about marine science, about conservation, and maybe leave legal matters to to the lawyers. So okay. Next, please. So, ako pala sorry. So let me start by pointing out actually that the Philippines is can be called as a body of water, no, instead of land, because of the mere huge area of the water, which is about 6 to 7 times bigger than our land territory. And water, as we know, Filipinos, is very important to support the livelihood of the majority of the Filipinos, particularly in fishing communities. So the health, the condition of our communities would actually depend on the condition of our marine ecosystems. Oops, sorry. And then let me further emphasize that the Philippines is very blessed. No? We're very blessed because we are located right at the Coral Triangle region. So this Coral Triangle region is the area which harbors the highest, no, marine biodiversity. The richest marine biodiversity in the world is within the Coral Triangle. So you talk about mangroves, you talk about coral reefs, you talk about seagrass ecosystems, you talk about fisheries. So we are located here, right at the area where those resources are richest. And if you notice that the Philippines, no, is right at the center, or we call as the heart of the Coral Triangle. In fact, Carpenter and Springer said that the Philippines is really considered as the center of marine biodiversity, particularly when it comes to fish. But however, we also know that the Philippines is very vulnerable to the impacts of climate change. So in fact, the Philippines itself is called the hotspot, no, for marine biodiversity. So in conservation, we call it as a hotspot if the area is very rich in terms of marine resources, but at the same time is also very threatened, no, from different sources, including climate here, as you can see, and anthropogenic sources. So out of based on this publication, sometime in 2019, it was determined that the Philippines is actually fourth, no, most vulnerable in terms of impacts of climate change, based on that climate risk index. And that's true, no? Later, I will explain later. And if we say vulnerable, it's actually a component of what we call as exposure. This is just a brief background, so we know what to do in terms of legal matters. No? So when we say vulnerable, it's actually a function of exposure, sensitivity, potential impact, and adaptive capacity. So exposure, it's like the location of the Philippines itself, no, relative to the impacts of climate change. So we know that the location of the Philippines, which is near the equator, is very exposed to, for example, global warming, because we're nasa equator na tayo. And then we are also located at the western border of the Pacific Ocean, which is called as the Ring of Fire. No? Daanan ng typhoon, earthquakes, tsunami, and all. So we are very exposed. In terms of sensitivity and adaptive capacity, that's in terms of how can we adapt in terms of adapt, no? How can we respond to impacts of climate change? So we know that the country is a developing country. We do not have much the resources, the technology to respond, to do something, no? To when there's disasters and all. So remember, for example, what happened during the Yolanda, Odette. Until now, some areas have not recovered yet. No? So what is really our kasangga, no? In terms of adapting, in terms of facing climate change, is our natural resources, no? Our mangroves, our seagrass, our coral reefs. So there's this rule of thumb, like healthy ecosystems means resilient ecosystems. So maybe what we can do as a third world, as a developing country, no, with less resources, is invest on our natural resources, because we do not have like resources to really technological resources and all. And just to point out here that really carbon dioxide, the accumulation of carbon dioxide in the atmosphere, is the main culprit, blamed by many scientists as to the cause of global warming, and especially the fossil fuels, the oil that we dig, no, from under the ground. So that's also that's considered the main culprit. And then these are some of the pictures of climate change: increasing temperature, storms, sea level rise. All those impacts we are experiencing it heavily in the Philippines. And those are just pictures of what happens to corals during global warming and all. But what I want to point out, and this is also I'd like to point out here, that because of the climate change, some species, no, our fishes might migrate poleward. No? So our fishes here might go to Japan, might go to Canada in the future. So we will be left with like a desert ocean. So I hope you remember that word, no? Because of climate change. But what I want to point out here is the role of human beings, no? in the destruction of our natural resources, in the destruction of the very thing that helps us face these threats from climate change. And we know that most of these impacts are done or are because of mga bigger companies, corporations. Just like, for example, our commercial fishers. No? So they constitute only less than 1% of the fishers, but they harvest almost half of the entire production. And then the shipping companies, no? When there's oil spill, so that destroys the environment. And then there was this, let me share this experience. We conducted these focus group discussions with fishers from Samal Island, and they said that they have been protecting the mangroves for over 10 years already. And then here comes a wealthy person, and then not the bridge before the house resort something, and then bigla nilang binuldos. So as they say that we all contribute to the destruction of the earth, no? But differently, but then we suffer equally. In fact, the fishers themselves, sila yung nagsasuffer the most. And that leads me, sorry na pahaba yung introduction. That leads me to some of the key questions that was provided to us as in terms of like monetary remedies. So in fact, because of this, we can maybe charge damages, compensation for losses caused by climate change. And when we say climate change, we should not focus only as I've explained earlier, we should not focus only on the greenhouse gas emissions. No? That's the main culprit, but we know that climate change, once you destroy our environment, then our vulnerability to climate change will become higher. We'll become more vulnerable. We'll become less resilient to impacts of climate change. And so therefore, we should also charge damages, fines to corporations, to individuals that destroys our environment. And then, yung mga funding for climate change. I think this is done by some corporations, especially mining. But we know mining is very destructive. And then yung mga environmental projects nila is very local, no, to specific area. But the bigger area is not like for example, wala masyadong project doon. And then we should, later na sa discussion because I have very limited time na. But what I want to emphasize also here, maybe we should tawag ito, promote transparency, no, and accountability pagdating dito sa activities ng mga corporations, because most of this hindi natin alam kung ano ginagawa nila and the impacts. In fact, balik ako sa commercial fishings, they do not even want to put like trackers in their boats, no? So we do not know where these fishing boats fish, no, because of the strict yung 1054 to prohibit commercial fishers from fishing very close to the shore. So I will expound later siguro. Thank you for the time.
Thank you, Professor Muallil. I think that also underscores the necessity for us to explore other avenues in order to seek the remedies when it comes to corporate climate litigation. As highlighted, it's not just one avenue where we can seek these remedies, but also through preventive mechanisms, such as, in general, investing in our natural resources. So thank you, Professor Muallil. May we hear next from our next speaker, Ms. Agnes.
So, good morning, everyone. Thank you for the sponsors and the convener of this important conference. I'm neither a lawyer nor a business management person. I'm a biologist. So, the insights I'm going to share is from the point of view of a sustainability practitioner in the business sector. So, the corporate litigation toolbox is already very comprehensive in terms of remedies. So I'd like to share my modest insights on two things. First, tackle or contribute to the issue on hurdles of remedies. And second, as prescribed by Justice Leonen, we in the business sector must do a reassessment of what we need to do in order to embrace our own climate responsibilities. Okay. So hurdle number one, the insufficiency of legal frameworks. Yesterday it was said that there are legal frameworks. If you link the Constitution to environmental statutes like the climate change, the Clean Air Act. But then even the Clean Air Act do not have standards for greenhouse gases and carbon dioxide. And therefore maybe it can be enhanced by various documents or legal documents in the business segment. One of those legal obligations or rules is the taxonomy. So the taxonomy is a classification system by which economic activities, there are criteria for economic activities that are aligned with the net zero trajectory of 2050. One of those is the ASEAN taxonomy issued on April 25, 2024. Another one is our own Department of Finance sustainability framework issued in 2022. Another and a more potent source of legal obligation is the one issued by the IFRS. So I think in June 2023, the International Financial Reporting Standards Board, or IFRS, that dictates the way we manage things in corporations across 121 countries, including the Philippines, issued international sustainability standards disclosure, mandatory disclosures. So they have two disclosure groups. So S1 is on general sustainability that includes human rights. The second release is specific to climate change. And what is important is this IFRS, or International Sustainability Mandatory Disclosures, have been adopted by our own Philippine SEC. In October of 2023, they gave us an exposure draft. All publicly listed companies were asked to review, and then they intend to issue it this year. Hurdle number two is quantifying climate-related disclosures for climate-related damages for monetary remedies. Now, I think there are three steps. Step one is trying to pin down the carbon footprint of a company. Now it is already very easy because the carbon footprint, especially for publicly listed companies, are required to be estimated, disclosed, and then calculated. Another one, you can get the estimates from emissions trading, meaning the national inventory is allocated and then you have a quota, and if what you cannot mitigate becomes your liability. Step two is actually attributing a ton of carbon to the impact, which is very difficult. So maybe 80% from carbon majors, 20% from companies. So an example is this, a company with maybe 10 million has 0.002, and then you go to the procedure of Jem Castillo on the environmental impacts of public interest. The third is the inadequacy of remedies for the greater or profound consequences of climate change. Stepwise, the first thing that business must do is to go beyond environmental impact assessment. You should do environmental and social impact assessment or environmental integrated assessment, because in the environmental impact assessment, you only look at the health, maybe health and economic impacts, but not culture and so on. So it should be ISIA. And once you know the impacts, the measure should not just be restoration, it should be regenerative, because when you do restoration, going to the original situation, we already have a damaged climate, damaged planet. So you cannot sustain a damaged climate, our planet. You need to heal and repair the planet, and therefore it has to be regenerative. Example, by just complying with the water rights so that there's the natural flow of water, why don't we ask companies to go beyond that and actually recharge the aquifer for water-based, not just reforestation within the concession, but beyond. The next step is we need to know the environmental and social impacts of the action of businesses, the externalities that are not costed, and that could go down to the ecosystem services. Why don't we ask for replacement of ecosystem services, all of these services, and as we said, the PENCAS law will actually do a natural capital stocking. They will have a site-specific ecosystem data so that you can see the changes in the natural stock. The next is the advice of Justice Leonan. Business must reassess itself. And the first thing is to identify and recognize your climate responsibilities. And the first responsibility of any organization, business or none, businesses big or small, is to have a climate transition plan to net zero. And in doing that, we know it's difficult, we know it's expensive, we know it takes time, but you should come out with short-term targets based on what is there. So for the emergency brake, while you scan technologies that can have, like carbon capture, that can stop the emission in the long term, and maybe a backup like nature-based solution. The second is the business must look beyond its business fence. It must look at the emissions coming from its suppliers, because they influence also the emissions of the suppliers. And therefore, you need to analyze the value chain from the material that you use, the emissions from that production, from the use of the production, including disposal. And then in our company, we're going beyond that, because our mission in our company in our conglomerate is forging collaborative pathways to a decarbonized and regenerative future as a reaction to Yolanda when our plant was damaged. So we joined the Ako Ang Bukas movement of Green Convergence, whereby we use the LGU as a platform because everyone is there, and then we created a calculator using the UN prescription and local prescriptions. And then in this session, we teach the people what is climate change, what are the measures, then they calculate, and then the measures are included in the local climate change action plan. We also link up with regulators, and this is an example of our pilot in Ormoc. So lastly, businesses must have a theory of change. Change because business must recognize that we are part of nature, and therefore, we depend on nature and we can impact nature. And therefore, business must go beyond financial capital and look at 6 capitals: intellectual, social, human, and natural, and go for a regenerative strategy. And therefore, in summary, in our case, in our conglomerate, we look at the value chain of the business. You start with a mission, forging collaborative pathways to a decarbonized and regenerative future, but you can only implement that if you have a business strategy that embeds it. And therefore, if you embed the multiple capitals, there's dual materiality. You create values for your business, but also values for others. Thank you for your attention.
Thank you, Ms. De Jesus. So two things we can learn from that. One is that while the initial question is whether the current remedies are adapted to the situation of climate change, maybe we should also evaluate whether the legal framework that exists is adapted as a whole. So as pointed out in the presentation, we can see that there are many avenues for improvement. And the good news is there is room for social involvement through the LGUs, and also there are extant procedures that are already adopted by the SEC, which our courts can also appreciate and integrate into how they evaluate the cases before them. So thank you, Ms. De Jesus. Now, can we have Attorney Grip?
Thank you. Magandang umaga po and good morning to everyone. It's a pleasure to be here again on the second day of the conference. I cannot help but react to what my new friend from Tawi-Tawi here said. It's always nice to hear from non-lawyers. And I'm sure, because sometimes if you give lawyers the microphone, they can speak and speak. And I got, but in one conference I attended, it was a conference full of oceanographers, marine biologists, and they were pleasantly surprised to see a lawyer in the room. I was the only lawyer in that conference, talking about protecting the oceans. It was a conference on marine litter. And I think it points to the importance of the multidisciplinary approach and learning from different disciplines. I apologize, I was not able to prepare any slides like the other speakers. But last night I attempted to draw something. And it's something that I will discuss. And I call it the Remedies tree. However, when my eldest son saw me drawing, he said, "Daddy, what's that? What are you doing?" I said, I'm doing a flow chart." He said, "Nobody will understand what you wrote, so, I will not attempt to show you the drawing." But essentially, what I wanted to do in this brief introduction was to point to a few steps on how we identify the remedies. Okay, there are, and I think there are 5 essential steps. Okay. First that you need to do is to look at the legal basis, I think. And by looking at the legal basis, you are looking at what rights are being affected. Okay. At the same time, it also points you to identify who the parties are. Who do you want to be who will be the potential petitioners who were affected? Who will be your respondents? Will it be the government? Will it be individuals? Will it be business organizations? And then and here you can also look at not just the impacts, but determine whether the problem is the lack of policy. Yesterday we were talking about having legal frameworks present, but in some cases, and I think Ma'am Agnes was also pointing that there are things lacking in our legal framework, which make it difficult to protect rights or to achieve sustainability, not just for individuals, but for businesses as well. And once you've identified that initial step, next is you choose your modality. By modality, I'm referring to 2 things. First, you choose between the national or the international approach. We'll go to the international first. International, do you go to an international tribunal to protect these rights? Earlier, we heard the speakers from the previous panel talk about ITLOS cases, cases in the ICJ, cases pending in the ICJ, or regional human rights bodies like the Inter-American Court. Unfortunately, here in Asia, I don't think we have. There is a working group for an ASEAN Court of Human Rights, but the court has not yet materialized in our own region. And then second, aside from looking at whether you go national or international, assuming you choose national, you choose between 3 strands. Do you go for the adversarial, the inquisitorial, or the lobbying and advocacy approach? Now, when you talk about adversarial, that is what we lawyers are used to. Party A versus Party B, presenting evidence before a judge, and judge evaluates the evidence presented, judge makes a ruling. Okay. So that's what we're taught in law school, the adversarial approach. On the other hand, you have the inquisitorial approach. And when you talk about the inquisitorial approach, this is the approach wherein the judge, well, there you may have a judge, or you may have a commissioner, you may have a head of a tribunal, gathering information, but at the same time, helping the parties, the opposing parties, come up with a solution. The judge or the person heading the tribunal is at the same time trying to find for itself the evidence that are needed, the information that are needed. We see here in the Philippines a mix of the adversarial and inquisitorial because of the powers of our judges. So judges here have the power to adjudicate, of course, in an adversarial manner. But they're also inquisitorial. In the rules of court, judges have the power to call friends of the court. They can actually direct motu proprio, ocular inspections, for example. But in jurisdictions like in Australia, and last year I got the chance to sit in the Land and Environment Court in New South Wales, the judge just listens. The judge just listens to what the parties are presenting because they are a strictly adversarial proceeding. And after I had tea with the judge, because the judge there was a friend of mine. So after we had tea after the session, and the judge was saying, I wanted to tell one of the lawyers to go do this, file this pleading, so that you can gather that kind of evidence. We can, and so that the court can gather those facts. But the judge cannot do that because of the limited powers in an adversarial proceeding. When you talk about the inquisitorial approach, going back to inquisitorial approach, this is where we're looking at other streams or other remedies. Like, for example, you go to your admin agencies. Admin agencies can be agencies like those in the DNR, EMB, Pollution Litigation Board. We even have the SEC. Agnes was talking about the SEC being now more involved about sustainability. Yesterday, we heard about going for consumer rights. So you can even go to our trade departments, for example. Or you can go to specialized tribunals. Yesterday, we heard about the National Green Tribunal. I mentioned the Land and Environment Court in New South Wales. These are specialized tribunals, not part of the regular judicial system, but can also provide, can also adjudicate on climate disputes. Then, of course, you have the other agencies, as I mentioned earlier, SEC, DTI. But again, their powers, their inquisitorial powers, would depend on the powers and mandates that they have been granted under the law. Now, the third strand is going for the lobbying and advocacy. And I think the professor here did mention about implementing projects like the Coral Triangle Initiative. That's also part of lobbying and advocacy. One aspect of lobbying and advocacy is going after laws which are missing, lacking legal frameworks, working with our legislators to come up with new laws and policies. For example, clarity on sustainability reporting. Whether do we mandate not just publicly listed corporations, but corporations with millions in assets, not listed, but having an impact on. I'm sure ma'am would have her comments on it. Or we work with international organizations. We work with the academe on projects which have direct impact. Now, once you've identified your modality, and you've chosen your venue, the next thing to consider is what are the external factors which will affect the type of remedy that we pursue. We look at costs. We look at how will you provide witnesses, the types of evidence that we need. Do we allow for virtual hearings, for example? Many courts around the world after the pandemic have allowed for virtual hearings. But for example, when you talk about costs, how do you now factor in, for example, if we want to go to ITLOS, and I think ITLOS sits in Washington, D.C., if I'm not mistaken. For example, or if you go to the ICJ, which sits in The Hague, for example. How do you now then bring let's say, your petitioners from the Philippines to appear in front of these international tribunals? Who covers the costs? What if you are talking about vulnerable communities, coastal communities which are being affected by climate change? How will they be able to go to the fancy, for those of you who've been to The Hague, the courts there are big, old, 100, 200-year-old buildings where these courts sit. Now, how do you then bring these vulnerable and affected communities at? So those are external factors that you have to look at. Then next, you'll have to look at what do you ask for? Do you ask for damages? Do you ask for restoration or reparation? Do you just want someone to be held liable under the law, fines and penalties? Do you ask for an injunction, or do you want something to be done by the government? Do you go for mandamus, for example? Or do you simply want information? Yesterday, we heard about discussions on access to justice, access to information, for example. So this will be part of your prayers or what you ask for. And then lastly, I think this is the critical step when you have chosen your remedy. And this is to, how do you implement the judgment? How do you enforce? If you go for the national setting, enforcement, implementation might be a bit easier because you have your national processes. But if you went to the international court, how do you then enforce these arbitral tribunal rulings, for example? Or if you did go for a transboundary case, and there are examples, let's say France has their duty of vigilance law, which allows foreigners to sue French-registered companies for violations of human rights and other related rights like environmental rights outside of France. So Total, I know, is facing some challenges from Indonesia and from some countries in Africa based on that law. So now you have to consider the transboundary application again of the remedy that you sought. Okay. Now, so you have that remedy tree which points you to what things to consider and the what remedies to apply. But I think, and my last point for these opening remarks is, we've been talking about corporate climate litigation, and one challenge is, and maybe perhaps later I can try to expound on this a bit if you do have time, is how majority of experts define what climate litigation is. Majority of experts like Grantham Research Institute, Sabin Center, and Columbia Law, they all ascribe to the definition of Merkel rule, which says that a climate case is a case which has climate law, climate change, or climate science at its core, at its center. And some groups like the Asian Development Bank and even some judges have said that this is quite a strict application of what climate litigation is or what a climate case is. And it doesn't capture other cases, like environmental law cases, like cases on forestry, cases on protecting fisheries rights, or even enforcement of environmental laws, which have both direct and indirect impacts on climate action. For example, just one example of this. There was one case in Fiji where it was a liquor license body. So you have an administrative agency, not a court, not even a specialized tribunal, a liquor license agency which issued a ruling which says that I will not allow another liquor shop in one of the islands in Fiji, not because there were already one or two liquor shops on the island. Well, that was the secondary reason. But the primary reason of the tribunal was that these liquor bottles, the liquor shop will produce more liquor bottles which will be waste, which the country cannot already deal with. And the short decision by that the liquor license authority even cited sustainable development and climate action as reasons for not allowing that. So you see, that's not in normal circumstances, that won't even be considered as an environmental case or a climate case. But if we broaden our perspective and we get to appreciate what lawyers like our panelists yesterday, our panel here today, and judges are doing, judges who may not be handling these big climate cases, but at the same time, they are handling environmental cases and even, let's say, corporate cases, energy-related cases, which may have indirect impacts on climate action. These also have to be recognized as part of climate litigation and as part of the different remedies that we can explore to promote adaptation and mitigation action. I hope I kept to time, and thank you for listening.
Thank you, Attorney Grip. I think that highlights two key aspects. First is the enforcement aspect, because one major problem is even if you win the case on the merits and you find that you have the appropriate remedy prayed for, enforcing it is another thing. I think this is why in law school there is several sessions devoted strictly on the enforcement and execution of a judgment. So this is also something to consider moving forward when it comes to climate change litigation. And to develop the necessary tools and strategies in order to enforce the awards and enforce the remedies that they or any litigant has prayed for. Another thing is the definitional issue that was pointed out, because we seem to have a point of view wherein it's only a climate change issue or a climate change case if it's at the center is a climate change related law. But as we know, a lot of quasi-delic cases or even breach of contract cases, civil cases in general, have their own implications with respect to climate change. And through this, maybe we can sort of develop a deeper and broader appreciation of how these interplay in terms of climate litigation, and inform the courts even more moving forward. So thank you, Attorney Grip. Just to round out the panelists that are here, and so we can move on to those who are present online, may we then have Attorney Reset, please.
Still alive. Thank you. Haven't had the chance. I didn't have the chance to prepare a PowerPoint presentation like two of my other co-panelists here. But I just want to make 2 points in this opening, in my opening remarks. First, in the DRR, we were actually a bit hesitant to accept this speaking invitation in light of the direction that this administration wants to head. We are the secretary has been emphasizing a multi-stakeholder collaborative approach in terms of addressing all our environmental challenges. And part of it, of course, is climate change. My division, which has been handling agreements, has been working overtime, developing these partnerships with the private sector, and of course our civil society. And of course, my division is also not the division that handles litigation. But of course, I've consulted the division that handles litigation. And we are not faced with, I am told we are not faced with any writ of kalikasan cases involving climate change. But yes, in terms of the policy perspective, in terms of thinking how, as a society, we can get towards our goal of limiting global warming to 1.5 degrees. We welcome the avenue that litigants have been taking. We understand this, of course, has its own value. From our perspective, it's hard because we are very short-staffed in terms of lawyers handling cases. So it's also hard to go after everyone, to go after all the violators. So we are taking the path of facilitating, as Ma'am Agnes has pointed out, facilitating that transition to a low-carbon economy, which is part of our Philippine development plan. So for us, the key is designing the right framework of carrots and sticks, incentives and liabilities to address the climate emergency. We see the litigation as the contribution of litigation as localized deterrence as opposed to our negotiations with other states. And as a way also for violators and victims to come face to face and see the effects of their own their businesses' own actions, and also as a way to encourage responsible business conduct down the line. So in terms of the legal framework, it's actually interesting that they pointed out the inadequacies of our legal framework. We're twisting ourselves in knots trying to find how a framework where climate change can fit, because right now we don't have a specific law that allows the redress of damages from climate change. But and now we are looking at tort, human rights, and as Sir Professor Muallil earlier said, we might also find relevant other environmental laws, as the violation of these can exacerbate our climate challenges. And also, it brings to the center the question of what is climate, what is a climate case. I actually looked at, when I was looking at remedies, pecuniary and non-pecuniary, I did want to highlight also some interesting provisions of the NIPAS Act, National Integrated Protected Areas Act, and the Wildlife Act as examples of our needing to see this litigation aspect as part of a larger strategy in terms of addressing climate change, where there are so many moving parts. We might also, when we start to look at these other environmental laws, we might also want to think about the differences in terms of the approach, as opposed to tort law, where you would require fault or negligence and a certain state of mind of a reasonable, an ordinary person with a reasonable ordinary person. Whereas in special laws, like the Revised Forestry Code, you don't actually need to show intent. You just need to show that there has been that commission or omission that led to the crime. So, like, our most common cases that deals with this is when you have someone borrows the jeep to transport the logs, the timber, and then the jeep owner doesn't know that that's what it's being used for. The timber that's been transported without proper documentation. So the jeep gets confiscated, forfeited in favor of the government, and the claim is, oh, I didn't know. But so for as a special law, that's a defense that we do not entertain. So I guess yes, I think I'll end with that and give other panelists a chance.
Thank you, Attorney Rosette. I think that highlights the breadth of the options available in terms of remedies and also the implications, which I think necessitates as mentioned, the multi-stakeholder approach or the discussed interdisciplinary approach. This is to enable not only those who litigate, but also those who are directly affected. For example, the owners of the jeepney who actually have no idea that it's transporting logs without permits. So it's important for them to be involved in this movement, and that we should not confine ourselves to traditional avenues of redressing the effects of climate change. So this is a welcome approach, and that this is something we can definitely implement moving forward. Now we can move on to the members of the panel who have joined us online, and may we call Attorney Niner, please, to start.
Good afternoon, everyone. Am I audible?
Yes, Attorney, you're audible. It's just a bit
Okay.
muffled.
Okay, sorry. I'll just try to make my voice louder. I apologize for not being there in person. We had I have a personal trip that I couldn't move any longer. But thankfully I was able to join via Zoom for this panel. So thank you for having me on this panel. Like Rip and Seth, I'm afraid I have no slides. So I will just be sharing my thoughts verbally without visual aids. Apologies for that. I think I'll start with how when speaking of concrete remedies in relation to climate change, perhaps a good number of us, compensation is among the first things that come to mind. I thought for my opening remarks I could talk a bit about the United Nations Framework Convention on Climate Change, or the UNFCCC, and the context it provides in relation to finance for adaptation and mitigation. So under the UNFCCC, there are no specific treaty provisions on liability and compensation between states. The word compensation, actually, according to UNFCCC negotiators at the time, was deliberately avoided. So in some ways, though, I see the UNFCCC as an attempt to provide compensation to states as victims of climate change, but in a more roundabout manner. So what the UNFCCC does is incorporate into its provisions an application of the polluter pays principle, but it avoids direct discussions on compensation by introducing or embedding the concept of additionality. At the Second World Climate Conference in October 1990, it was recognized that additional financial resources would have to be channeled to developing countries for their activities that would contribute to mitigation and adaptation actions on their part, arising from what they refer to as a climate debt, so to speak. So this climate debt is made up of an emissions debt, which is the amount of atmospheric space already used by developed countries in relation to their own historic greenhouse gas emissions. It's also composed of an adaptation debt that is owed by developed countries to developing countries and is meant to help them adapt to and respond to climate change and the need for provision of finance to developing countries. So the purpose behind the provision of finance under the convention is therefore twofold. It's to answer for historical and current emissions leading to changes to climate that we are currently undergoing, and to provide developing countries with much needed resources to undertake climate action. So Article 4 of the Convention, particularly Articles 4.3, 4.4, 4.5, and 4.7, refer to the provision of finance by developed countries to developing countries as a consequence of their historical responsibility for climate change. So for developing countries, effectively meeting commitments under the convention is in fact made contingent on this provision of finance, which is characterized as new and additional. This concept of additionality differentiates financial flows from developed to developing countries that are meant to increase economic development and public welfare from financial flows that are meant to compensate for their historical and current greenhouse gas emissions and/or support the latter in the conduct of their climate change actions. So while under the UNFCCC, there is no reference whatsoever to compensation, there is an obligation to provide finance to developing countries which are acknowledged to suffer the most from the adverse effects of climate change through little fault of their own by developed countries which are recognized to have historically contributed to its occurrence. So the evolution of the term climate finance and finance under the UNFCCC effectively and its inadequacy under the convention through the years now sees the involvement of the private sector as a source of funds. Um, Mention of this appeared first in the UNFCCC's Bali Action Plan in 2007, which speaks to the enhancement of the provision of financial resources and investment action to support mitigation and adaptation action, including the quote, mobilization of public and private sector funding and investment, quote, unquote. The provision of funds in this context is still framed as part of the obligations of developed country parties to developing countries due to their historical responsibility. And in order for developing countries to undertake their own adaptation and mitigation actions, but it takes it a step further through its outright recognition of the private sector, broadening the scope of potential sources of funds. So there's still no mention of compensation, but this recognition of the private sector under the UNFCCC process, in this case, stems from a finding on financial flows to address climate change of the private sector's greater capacity to finance climate action in relation to public sources, in comparison to public sources, rather. So as a result of this, a particular focus has been placed on the sector alongside the provision of finance. This development interestingly falls in with progressive actions that have been developing through the years to finding ways to directly hold responsible the private sector for their contributions to climate change, which I believe we'll be talking more about in this panel. So I will stop here for now. Thank you very much for listening.
Thank you, Attorney Niner. I think this also highlights, to borrow from the Remedies tree, as explained by Attorney Grip, the modalities by which we choose to go about enforcing our rights as provided in climate change and climate change law, meaning that we can also resort to international actors or the international pathway through going through our own state channels in order to have our rights enforced and ultimately holding private corporations responsible for their contributions to climate change. So thank you, Attorney Niner. May we now call on Ms. Shibani Ghosh to speak.
Hi, am I audible?
Yes, ma'am.
There is an echo at my end. Is there an echo in the hall as well? Is there a problem?
On this end, you're all clear.
Okay, great. So thank you so much for the organizers for having me as part of this session. I'm sorry I'm not able to join in person, but it's really a delight to be able to do this virtually now, given technology. And it's really been wonderful to hear experts from other jurisdictions, as well as experts not from the legal community. And it's always very nice to have an interdisciplinary approach to a problem like climate change, which is clearly a complex challenge. It's not only a science challenge, but it's really a complex governance issue, and certainly something that doesn't have easy problems. And therefore, as part of the legal community, when we approach the judiciary to solve something that we ourselves are not entirely clear about its parameters and how can it be solved and whether there are some obvious and clear remedies, we're really on the back foot, right? So, I mean, it's the judiciary itself has not traditionally been either exposed to these issues or sensitized. Of course, we do now have, as a panelist before me spoke, many countries now have specialized tribunals to discuss issues of environment and natural resources. But even in that kind of jurisdiction, climate change is still very new. So given my kind of area of work, which is based in India, I'll speak today. My remarks would be restricted to India. I cannot say I know enough about other jurisdictions. Climate change litigation is very much at a nascent stage. Unfortunately, I was not able to attend the session yesterday, where I believe a senior colleague of mine was also speaking on India. But it's very much at a nascent stage, and I think someone spoke about the definition of climate change. And if you were to look at what climate change litigation really means in India, I think we would take a much more, what the global South definition of climate litigation is, which is much broader and wider than the Merkel and Rule definition that was mentioned earlier, which is not just that climate change is the core of the issue, but much wider in the sense of having arguments being raised by the parties or the courts raising climate change as a reason in its order. So in that sense, India has had some decisions lately, and there has been a landmark judgment recognizing a right, which perhaps was discussed yesterday as well. But in terms of remedies, which is really the issue for this panel, we are very thin, and I can't speak much from precedent or case law as to what remedies on mitigation and adaptation have been deployed by our courts as of now. But traditionally, in environmental cases, our courts have been open to granting compensation, giving restoration damages, restitution. There's been declaratory relief, injunctions have been granted. So all of that toolbox, I guess a term that has been used here, is fully available to those approaching the Indian courts on climate issues as well. But there, I think we all have to be a little cautious in India as well as other jurisdictions, I'm sure, that given the nature of climate change, the damage that we're talking about, the causes of climate change that we're talking about, people talked about how this is in the earlier session, that how this is clearly a transboundary issue. We are not looking at what are traditionally environmental issues, that here is the cause and here is the damage and here is who's going to pay for it. So causation and all is rather complicated. But the added problem here is in countries such as India, many of these issues are inextricably linked to economic and strategic decisions. And therefore, the government often takes that to be its defense when it comes to such cases where they are challenged as to why have you given a permit to a particular project, which would have a significant impact in terms of emissions, or why have you given a permit to a project in an area which is already ecologically fragile, and therefore you are going to, definitely hurt the adaptive capacity of a particular vulnerable community. Often the response there is that as a developing nation, we have several imperatives, given where a significant part of our population lie in terms of economic and social indices, we need to bring them up. And therefore, perhaps climate is not an imminent issue that we need to take into consideration. So as lawyers, we are often faced with that defense coming from the other side. More often than not, that defense, I believe, lacks in full reason and evidence. But that's what's coming out. And therefore, the court in that sense is restricted, at least in many of the Indian courts, are restricted in the terms of remedies that they are able to give out. One of the kind of routes or the category of remedies that Indian courts have often resorted to in environmental issues, and therefore in many of cases in which climate has been raised, is it's form of a declaratory relief or a mandamus to the government agencies, saying one of the following few things. One, that here is a rule or here is a policy that you've already come up with. Make sure you implement it properly, and that's all we are going to say. We have our full faith and trust in you that you will have the ability to do so. We're not going to say any more, but we think you need to get on with it and do that. The second thing that the court could say is that there isn't enough in this area right now. For instance, in the recent judgment of March, the Supreme Court said we do not have an umbrella climate legislation, that India does not. And therefore, it kind of uses different hooks in the other, for instance, the Constitution, it looks like the right to life and right to equality. And therefore, kind of looking at hooks in other environmental legislations and the Constitution to give certain remedies, which could be in the form of setting up an expert body. And in that sense, the court kind of realizes its limitations in kind of resolving some of these issues, right? And we had a fantastic presentation, of course, based in Philippines, but that kind of laid out how complicated some of these issues are. And imagine having our judges trying to resolve these on their own. And I don't think it's possible or even advisable. So in some senses, having expert committees being set up. But there the caveat again is, who has the seat on the table? How robust is the evidence gathering, how well it's been analyzed, what kind of considerations have been taken into account by the committee first, in fact, subsequently by the judges. So, I mean, all of these issues are kind of important when we're thinking of remedies coming from Indian courts. But the other aspect I also want to highlight, because, the panel talks about both mitigation and adaptation. Oddly enough, India is kind of, in terms of adaptation and courts, we are lagging behind even further, which is odd for two reasons. One, because India is obviously one of the most vulnerable countries, given the demography, the geography, massive coastline. We do have massive issues on adaptation, and our communities and the population that's going to be affected is huge. But secondly, just in terms of our jurisprudence, we have a very, very solid rights-based environmental jurisprudence that has evolved over the last 40 years. And if you look at adaptation claims across the world and different jurisdictions, adaptation claims align very well with rights-based claims. And oddly enough, India hasn't had enough of those, right? So when these claims are not coming to court as much as we would expect them to, the court's remedies that it comes up with are often not in terms of upholding rights, recognizing rights. Apart from the recent judgment, it has often been, as I said, along the lines of asking the government to do something or not do something. And unfortunately, there have also been many cases where the courts have felt the government, whatever it is doing or whatever it has submitted in court, is sufficient, and therefore they don't need to intervene at all. So I'll just end here in terms of my opening remarks that there are many other forms of remedies that the court, and there was a conversation about tortious remedies earlier. India, being a common law country, has a extensive tort jurisprudence, but not one that actually has been at all used in the climate change context. So there we do have opportunities to do it. I can't say we have explored much of those. And our courts in some cases have been hesitant to get into some things which are clearly what they perceive to be something falling within the executive or the legislature's domain. So giving all those caveats, I mean, I'll stop here and I'm open to responding to questions as they come along. Thank you so much.
Thank you, Ms. Ghosh. I think one important highlight of that discussion is the balancing of the competing interests between the economic implications of certain corporate activities with respect to employment, of course, which trickles down to the people who are afforded job opportunities and sources of livelihood, and of course, the ecological impact. And from my perspective, I think the discussion of Ms. Agnes is important in the sense that in order for there to be a balance, the system itself should be baked in. The sustainability in terms of the corporations themselves must police themselves, and the society wherein these corporations operate should also take the initiative to police these corporations so that there would be no need sometimes for it to go to court where these difficulties are faced. So thank you for that, Ms. Ghosh. Now we move on to our next presenter, Ms. Kanchi Kohli.
Yeah, am I audible and clear?
Yes, you are, ma'am.
Yeah, thank you so much. And I think it's been very interesting to get up in the morning and get straight into this discussion with a cup of coffee. It also shows that this is, I think we are globally connected by both the problem and solutions. And I think it's been very interesting to listen to all the previous speakers as well. So I think given that I've had the advantage of many of you coming to speak before me, and I think several of the issues have been, have been raised in some way or the other, what I'll try and do is just build on some of what you've said and not try and repeat some of the questions so that we can even have some discussions subsequently. I think from what I've gathered, and I think if I have to build on what many of you've spoken about and is also the larger discourse, what I wanted to start with is with a few points. I think I'll try and speak to that. Is that generally when we think of climate change, a lot of the discussion emerges as thinking about the future. So, it's often about, okay, the past is what it was, we need to address it, but let's start planning for the future. And I think this kind of gets completely challenged with the complexity of the idea of remedies. Remedies are about the past, they're about the present, and the future. And I think this is the complicated and the complex nature of the idea of remedies. And I think in the climate discourse, it creates further layers of complexity, because I think these remedies need to be and especially when we're talking about legal and non-legal remedies. So, remedies that are available in law, and remedies that actually reduce harm or address the harm or address legacy issues. So I think if you see a much more broader understanding of remedies, so they are, and that's why this sort of interdisciplinary panel becomes interesting, because it is about how do you carve out holistic remedies that deal with social, economic, ecological questions all at the same time. Is it even possible? Can you actually carve out remedies that are looking at local manifestations as well as global persuasions all at the same time? So, and all of it keeping in mind that it at any given point of time in specific geographies, past, present, and future might be operating together. So, when you actually bring all those three things together, it becomes, because you're talking about phasing out of something, you're trying to address something which is current, as well as you're moving towards something else. And this is crucial, because you're dealing with both impacts of what you're phasing out from or trying to phase out from, and also dealing with the impacts of the solutions that you're putting out right now. So whether it's renewable energy or carbon offsets, etc. So remedies are a question for that we're trying to deal with for past impacts, as well as what we are seeing as solutions that might be throwing up new challenges. So these are, with that background in mind, and I think I thought I'll build on some of what you said and just add this layer to the discussion as point number one. Now, point number two, I just want to flag is that most countries in the global south, at least, are, and I think climate litigation also is dealing with this, is relying on both the policy as well as the legal architecture to design remedies or address issues. So it's about the policy priorities as well as relying on the existing legal frameworks. And I think both these sometimes are, sometimes speak to each other, but sometimes can be at odds with each other. So your laws might require you to do certain procedures, but as previous speakers have spoken about, either the policy priorities don't fall in favor of those procedures, or they are in defense of those procedures. So in some senses, the priorities and in the legal frameworks may not align. Yet, when courts are confronted by challenges, they have to either rely on the policy priorities, which is often thinking of the future, and the domestic legal framework that is giving you some sort of benchmarks through which you are addressing the issues. Now, given that, I'll just reiterate my third point, which is basically, when you're talking about efficacy and adequacy of the legal frameworks, which is one of the questions that was posed to us, is that, I think there are three aspects that we need to, sub-aspects that we need to deal with the efficacy and adequacy, and I'll wrap up after this, is that remedies are clearly and also a result of a failure of administrative action. And often climate litigation is also relying on administrative action to resolve the problem. So if there is an administrative action that is not in favor of those remedies, the actual operationalization of judgments and orders also gets challenged. The other 2 points have, the second point has actually been raised by several speakers, is about difficulty in attribution and evidence. In any case, in environmental matters, it's an issue. In climate matters, it's a double, triple problem. But I think what I'll add to these two is just another layer, which is about standards. None or weak, when you talk about holistic remedies. You may have econometric standards, You may have some legal standards as principles, but when you're talking about a complex problem with complex dimensions, are there principles that can design remedies like that? And to the best of my understanding, those are often challenged, and they're not available as ready reckoners for lawyers or litigants or policy practitioners. So given that, and I won't get into the judgment, which I think Shibani has also spoken to, and I think you may have heard about it yesterday as well. What I want to just actually flag in the end is that I think it's important to, and I think we are all cognizant of the fact that there are limits to climate litigation in terms of carving out remedies. And I think in that light, the tango between policy and litigation to actually carve out remedies is very crucial, because if you don't have clear policy frameworks within which you can deal with complex political matters, which are both local and global, I think it's going to be harder and harder for lawyers and courts to do this very far removed from realities. Yeah, I'll just end at that. Thank you.
Thank you. Ma'am, I think what this highlights also is the inherent limitation that's posed on litigation and the remedies that it affords, meaning that it's reactive. The most concrete example I can think of is for actions for torts or actions for injunction. It presupposes the existence of something. It cannot be anticipatory, even when it comes to mandatory injunctions, or when a certain body or a certain person is mandated to do something, there must be an existing duty. So when it comes to future proofing or just planning for the future in terms of climate litigation, I think it's also important to focus on the policy aspect as pointed out, so that we know we don't have to confine ourselves to the remedies that are afforded by the current legal framework, but that we're constantly developing it and constantly adapting. So thank you for that, ma'am. And now we move on to the next speaker, Mr. Ahsan Qazi.
Good morning. I am honored to represent, to share perspectives from Pakistan at this significant conference. I thank the organizers and fellow participants for providing this platform to discuss these critical issues. I am a policy advocate based in Pakistan, and I would first just like to just really thank my two colleagues from India for really setting out the picture as it is in what I would like to call the global south. Just to give some background into Pakistan's specific context in all this debate, we know that it's one of the countries that's most vulnerable to climate change. We face severe climate stresses and impacts, including frequent floods, droughts, and glacial melt. The 2022 floods were the example of how really bad we have it here. 33 million people were affected. Economic losses were about estimated to be 30 billion US dollars. So that just highlights the urgent need for effective climate action. However, as my two colleagues already mentioned, Pakistan also has been facing this conundrum in terms of strategic and policy options and climate action on the other side. Historically, we have been relying as a state on the argument that we are a low emitter, we have produced less than 1% of global greenhouse gases, and therefore we may be allowed certain leeways. But the facts really tell us that this argument is becoming increasingly untenable. The risks and the disaster that we are facing is really not allowing us any leeway with respect to that. So there's this problematic approach of the state, which is at times quite visible in every facet of the government, whether you're dealing with judges here or parliamentarians here or active or the executive or the administration here. We may be allowed certain leeway. There's this economic consideration, there's developmental consideration, so on and so forth. Then there's also this we're the fifth biggest country, 220 million people, rising poverty levels, pressing need for development. And then balancing these needs with climate action becomes really challenging from a strictly policy perspective. 24% of our population lives below the poverty line. We face significant energy deficits, which is hampering growth and development, which is also why we have to, the state has to resort to building of coal-fired power plants, for example. And the sum total of all of these issues is that climate change in Pakistan, issues of climate change really, and maybe my colleagues in India can possibly attest to this as well, really becomes a governance issue as opposed to strictly an environmental one. It's really about the lack of governance in certain areas, and the reason for that is certain policy, economic, or strategic considerations that the government has to, or the political class has to follow. This unfortunately leads both the corporations and the state to engage in unsustainable activities. Large-scale deforestation is happening. Reliance on fossil fuels continues to thrive. We're building more coal power plants, displacing more people, more land. But at the same time, the state is having difficulty balancing this. Like our counterparts in India, the Supreme Court and the courts system, the judicial system here in Pakistan has been very proactive in dealing with environmental cases and considerations. The first case, which established a rights-based approach to the right to environment and the right to health and the right to life, was back in 1994. Since then, we've had progressively good judicial application of the right to a healthy environment. And more recently, the environment itself has been recognized as having a distinct legal personality. So quite progressive judicial determinations have been made over the years. But the issue really becomes, if we see the effect of these things on ground, do we see them really? Unfortunately, no. Because these legal victories that have been happening over the past 40, 30 years, access to courts remain limited, the process is slow. The issue really is at a structural level, and this low emitter argument that has been ingrained in across all policy actors really hinders any kind of development on this front. The public also and the environmental activists and policy advocates are also aware of this issue at this point, and there is a clear nexus between inadequate governance and corporate irresponsibility that emerges as a result of this. So, with this entire conundrum in mind, what are some remedies that can work? We're really, in Pakistan's specific case, we're really stuck in a very tight space. The remedies that we need to think about need to go beyond mere compensation or be beyond monetary or declaratory effect. But we really need to target, in my opinion, and it's the opinion that's shared with policymakers here as well, is that remedies should be targeted at behavioral or mindset changes. Why is that? Because compensatory and declaratory remedies are just not cutting it anymore. There's this famous phenomena in one of the cities in Pakistan, Lahore. Every year in the months of November and December, there's this phenomena of smog. Like it's completely blankets the entire city. Visibility is very poor. Air pollution is high. There's a lot of particulate matter in the air, and recent research suggests it might prolong living in such an environment might even take 5 years off your life as well, life expectancy. Every year, a case goes to one of the courts in Pakistan to fix this. The court gives some form of declaratory relief. The court, reprimands a few government officials here and there, but you're not seeing a mindset or behavioral change over long term. The same case happens every year. So yes, we are getting redressal through the court, but systematically nothing is changing on the ground. So one, we need to look into alternative remedies. The other thing is we need to look at out-of-the-box approaches. such as involving development partners. Like most countries in South Asia, in particular, in Pakistan specifically, heavily rely on a lot of development agencies and multinational development banks, such as the ADB and the World Bank, for a lot of development projects on a big scale. Involving them and requesting their input on a lot of projects sometimes helps as well. Very recently, just last year, there was this huge project worth 27 billion rupees. It was a freeway being built right next to a river, which was not ecologically sound or environmentally sustainable. So what a few people did, they gathered together, a few lawyers gathered together, they petitioned the Asian Development Bank, which was funding part of the freeway, and they requested them consistently to reconsider the project on the basis of certain EIAs that they had conducted. As a result, the Asian Development Bank pulled out from that project. So that is something that can be done to leverage MDBs and development partners. UNDP, for example, does a lot of development work in Pakistan. You can leverage these agencies to sort of affect action on part of the government mostly. The other remedy is that a lot of nature-based solutions have been developed by Pakistan, Living Indus Initiative, Recharge Pakistan, restoration of mangroves, so on and so forth. Perhaps corporations or any climate action or litigation that goes, I mean, this is specific to remedies where monetary compensation is being sought. They can be pooled into these nature-based solutions. Plenty of these have been developed by Pakistan. Most of them are mentioned in the NDC that Pakistan has submitted recently. Compensation can go towards those because we are seeing repeat cases every year. So if that unfortunate pattern is to follow, at least something good can come out of it. We can also perhaps look at master settlement agreements between the host country in particular and the major industries that have been emitting GHG emissions in that country. So for example, in Pakistan, textile, sugar, and agriculture are three big industries that are emitting greenhouse gas emissions. Perhaps we can engage in some form of master settlement agreement with them, similar to what this is something we're looking at. We're not really sure with what the modalities might look like, but on the peripheries, this is an idea we have been considering, similar to what the US did with big tobacco. It's not going to be easy, involves a lot of moving parts, but this is something that can be done. With this, I would end my remarks and look forward to the questions. Thank you.
I think just as a footnote to what was discussed, it highlights that the judicial avenue is not really enough because access to courts does remain an issue, and if our only avenue is the judicial, then we will only, to borrow the Philippine court language, clog the dockets. And of course, what we see in jurisprudence are only those who were able to litigate their claims all the way up to the Supreme Court, but this also ignores those who were deprived of access and those who were not properly equipped with the finances or the other resources for them to be able to litigate their claims and enforce their remedies. So thank you, Mr. Qazi. And for our last presenter, may we call on Professor Eri Osaka.
Okay. Thank you for including me on this panel with other specialists on climate change. So I'm the last person to give introduction for this panel. So I'll briefly explain the possible remedies through climate change litigation in Japan, contribute to the panel discussion later. So there have been relatively few climate change litigation in Japan. Despite the significant efforts of plaintiffs and their lawyers, these cases have not been successful so far. However, two cases are still pending. This one, Kobe Citizens versus Kobe Steel, a civil lawsuit. The other one is Yokosuka Citizens versus states, Japanese government. It's an administrative lawsuit. These are the existing laws on addressing climate changes. Act on the promotion of global warming countermeasures is mainly for climate mitigation, and the Climate Change Adaptation Act is for climate adaptation. Other than these two laws directly regulating climate change, several laws directly or indirectly address the issues relating climate change. So in Kobe Citizen versus State, this one, and Yokosuka Citizen versus State, this one, plaintiff requests to cancel the notice of finalization of the environmental impact assessment regarding the coal-fired power plant. While both cases are administrative lawsuits, I'd like to examine what civil remedies may be available in climate change litigation in Japan to correct inappropriate corporate behavior. So here are the possible monetary remedies, even though Japan has no climate litigation cases so far demanding monetary remedies. Possible course of action under the civil code are torts and contracts and unjust enrichment. Let me focus on torts. Against a single emitter of greenhouse gas, Article 709 of the Civil Code applies. The plaintiff must show the emitter of intention or fault, the illegality of the emitter's act, causation, which consists of factual causation and legal causation, and damage. Among others, proving causation between the emitter's act and the plaintiff's damage is the most difficult, as the last panel discussed. If a person sues two or more emitters of greenhouse gas, Article 719 of the Civil Code applies. There are three types of joint torts, but when we pass the liability of joint actors for climate change, the basis of liability will be inferred by the latter clause of paragraph 1 of Article 719. In that case, the plaintiff must show each emitter's intention or fault, the illegality of each emitter's act, and damage. Then the burden of proof is shifted to the defendant, joint actors. If joint actors cannot prove their contribution to the damage caused by their joint act, they must be responsible for the damage. However, under the Supreme Court interpretation in the asbestos construction workers case, because many other greenhouse gas emitters are not named as defendants, so the damage award will be quite small, even if the plaintiff overcomes their burden of proof. On this slide, let me focus on injunction and remedies for greenwashing among these possible monetary remedies. The injunction was already tried at the polar bear pollution conciliation. And Sendai Citizen versus Sendai Power Station, and Kobe Citizen versus Kobe Steel Limited. So this case, as I said, is still pending at Osaka High Court now. When the person wants to stop the construction or operation of facility contributing to climate change, or wants to reduce greenhouse gas emission caused by someone, in injunction case, she must show infringement of her right or possible infringement of her right, and the causal relationship between the defendant act and her damage or possible damage, and the legality of the defendant's act. In the Kobe Citizen versus Kobe Steel case, the Kobe district generally acknowledged that the injunction could be sought based on the concrete risk of moral rights or personal rights violation due to climate change. However, the court didn't recognize the concrete risk in this case and denied the causation. So the plaintiff lost and then appealed now. Regarding remedies for greenwashing, last October, two environmental NGO in Japan, Kiko Network and the Japan Environmental Lawyers Federation, JELF, filed a petition to the Japan Advertising Review Organization, with JARO. The petition requests a recommendation to cease JERA, the power company's advertisement. They said zero carbon dioxide emission thermal power generation. This is climate greenwashing against the act against the unjustifiable premiums and misleading representation. And also, the Ministry of Environment in Japan published guidelines for environmental representation. So the two NGO argue that they breached these act and guidelines. And later, the two NGO also did similar request against the Kansai Electric Power, NJ Powers. They also state that we are doing zero CO2 emission. So far, JARO hasn't replied yet. So this is my last slide. I also list the possible remedies that need to not be obtained in climate litigation, but could be achieved through political and economic processes, such as environmental due diligence and shareholders' climate proposal under the Company Act. But I think my time is already up, so let me skip this explanation. So thank you very much for kind attention and looking forward to the discussion. Thank you.
Thank you very much. With the kind permission of the chair of the session, just one, I know it's lunchtime, so we are very much aware of that. And so maybe just to get your thoughts, we'll make the question more comprehensive by asking, a lot of the remedies that you mentioned speak to what you can pray for and achieve as an outcome in litigation, but do they fit in our general framework on mitigation and adaptation? A remedy, for example, in any given litigation, whichever jurisdiction we may be talking about, will address the specific harm that the particular plaintiff had alleged and happens after the fact. But is this framework consistent with what our policies are internationally and locally on mitigation and adaptation, which we understand from, let's say, Attorney Seth's presentation earlier, requires collaboration among the sectors, and therefore we were asking whether this entire thing is counterproductive in that sense, I would say, or does not address at all, or does not fit in our entire framework on climate action. So that's a broad question that can accommodate all views from different perspectives, I would suppose, and it's a good way to also cap our session. Thank you. So, Mr. Chair?
Would anyone want to take a first crack at answering Prof. Mike's question?
I think there are many monetary and non-monetary remedies. But I believe that it doesn't really address the impacts of climate change, because most of the remedies are on the losses of persons, when in fact the design of the earth is interconnectedness. And therefore the impact of climate change continues from the natural system to social system to environmental system. Second, I think the way to do it is there is wisdom in concentrating on the companies, because I just completed the Philippine Climate Change Assessment Report, and definitely more than 50% of the greenhouse gas inventory of the country is with business. But then again, how do you mobilize them in addition to litigation or beyond litigation? You look at their pain points: compliance, and the oxygen of business, which is investment or money. And therefore, there is wisdom in linking the things that we want, either in governmental policies or in investor demands.
Thank you, Ma'am Agnes. Anyone? Attorney Greg.
Thank you. Graded ba to, Prof. Mike? Hindi na parang recitation question siya. No, but kidding aside, I think this is where several of the speakers already mentioned the distinction between the global north and the global south. And those causing climate change, presumably most in the global north, and those mostly impacted by climate change, the global south. And I think once you start with that distinction, that is where you will know whether your remedy should address mitigation or adaptation actions. For example, in the Netherlands, when they filed the groundbreaking Urgenda Foundation versus the Netherlands case, the Netherlands, they are not so much affected as by climate change as compared to the Philippines or Pakistan and other countries. So they focused on targeting their government policies by saying that your 20% target is not ambitious enough to meet the duty of care standard in our civil code. So that is a mitigation action. Whereas in most other countries which are vulnerable to climate change, they will target adaptation actions. Earlier we heard the example from Pakistan wherein they didn't use the court, but they went to a multilateral development bank and asked them to stop funding a project because this will exacerbate climate change. Again, it's an adaptation measure because we want to keep that river free to absorb more water because of the increasing rates. And given that you have to look at that distinction between the global north and global south, I think this is where creative lawyering for the climate will come in, if I can use the term. And when lawyers start being creative by looking at the different remedies that we've discussed today, you are now able to find the right and appropriate solution to the climate issues which are specific to the country. It may be through the courts, it may be through non-court remedies as what we've been discussing in the panel. But I think the important thing is to know that you have both legal and non-legal tools. To borrow a term from Attorney Oposa, he used to have a book called The Legal Arsenal for the Environment. So you have this legal arsenal, both under the law and not, which you can use for climate action. And in my last point, and I think this ties in well with what Ma'am Agnes said, that yes, businesses are the usual target. 50%, more than 50% of emissions in the Philippines come from businesses. But at the same time, we have to see them as partners also, I think. And this is where the non-adversarial route might come in. While listening to the panel, I was reminded of a study I did back in 2021, wherein I surveyed Philippine law to see how it talks about the role of businesses. And surprisingly, as early as PD 1151, we already have provisions which says that cooperation with the private organizations and entities for the environment for future generations, for example. And you have newer laws such as our Philippine Green Jobs Act, Climate Change Act, Clean Water Act, all calling for greater private sector participation in protecting the environment. I think Attorney Rosette would know more of these provisions. So there are already, even in our legal frameworks, there is already a mandate for us to work with the private sector, with businesses. Yes, there may be some businesses who do not support adaptation and mitigation action, hence the remedies, but at the same time there can be non-legal or non-adversarial remedies to address the climate crisis. Thank you.
Thank you, Attorney Grip. Anyone else from, yes, Attorney Garcia.
So I'll speak about the Philippine policy. There is no, so I looked up all the policies related to climate change. Of course, there's no mention of climate corporate litigation. But you can see it related, it's related to enforcement of environmental laws, which leads to the enhanced resiliency of our ecosystems. Second, it leads to also increased means of implementation, where you get these damages under the RPEC, where there are no private parties. It goes to the, it goes to the government, but we will use it for to address the implementation of the law that was violated. And third, I would also like to also move to the private sector engagement that's highlighted in everywhere in our plans and policies. It's actually private sector engagement is actually one of the identified risks of where we don't have it, we will not be able to achieve our nationally determined contributions. So that's how important we see private sector engagement, and not just in terms of the sticks. And with this, I want to also point to the evolution. I am seeing also with the current congressional bills, there's actually a Climate Accountability Act bill filed by Congressman Chato, which directly gives that remedy for to file suits against carbon majors. We also have the low carbon economy bill, which seeks to establish a cap and trade system where each where identified sectors would have specific emissions targets, and if you violate those, you would have the application of the polluter pays principle. I also invite you to look at the new bill that was passed under this administration, which was actually pointed out by Ma'am Agnes, the Philippine Ecosystem Natural Capital Accounting Act, which seeks to provide value in terms of to identify the value of our ecosystems. And I'm seeing I'm wondering how all these these developments in terms of our awareness of our climate responsibility would affect the standard of care that the courts would require. I'm seeing where there is greater awareness among the business sector. The courts, I imagine, would also have a lower threshold in terms of claims of not knowing that that their actions are causing damage or climate change impacts. So I think that's there. Thank you.
Anyone from our online panel wish to share their thoughts?
I had one comment, if I could come in. Am I audible?
Yes, you are.
Yeah. Okay. No, just wanted to say, I mean, the question was also, and I think Kanchi also put it in terms of we have to look in the past, present, as well as the future, but just addressing the future aspect of it. I think courts, and I can speak from the Indian courts, can play a role in ensuring that there are systems set up which ensure that future decisions which are likely to either contribute to climate change or impact the adaptive capacity of our population is not negatively affected. So, for instance, if there are laws being passed or rules that are being passed by the legislature in the country, which in some senses places India on a back foot with regard to its preparedness to climate change, then the court should be able to step in and say, look, this is going to create a problem in future, so you need to rethink this. And also to ensure that processes, I mean, access to justice and access to information was mentioned, but also people who get the seat around the table. What are the processes by which decisions are made? Are climate change considerations taken into account? And how are they taken into account? At what stage are they taken into account? What kind of evidence is being brought into place? I think the courts can really play an active role to ensure not only facts of issues that have taken place or are underway, but also to ensure that that we are better prepared to face what is going to come in future by ensuring that there are processes. Because courts in India, at least, are not well placed to give you a decision in anticipation, but at least they can tell the government to ensure that there is the procedure is robust, based on evidence, based on proper participation. And I'll stop there.
Shibani, Ghosh. And with that, unfortunately, in the interest of time and in the interest of lunch, we will now conclude the session. I'd like to thank everyone, both online and in-person members of the panel, for your time, for sharing your knowledge, and hopefully we can come up with a workable pathway moving forward. Thank you, everyone.